edit it, edit it, edit it. Let me see, it might still work. There we go, it still works, still works, still works. All right. Now we're going to go to, that does not still work. Okay, so we're going to edit that. What's up, everybody? What's up? What's up? Now let's see if that works. It does, it does, it does. We're going to pop out the chat. We're not going to do that. We're going to go to bright mode. Then we're going to pop out the chat. What's up, everybody? What's up? What's up? What's up? Then we're going to pop out the chat. And we're going to do that. All right. And we're going to mute that, minimize that. All right. And we're going to adjust that. Here we go. Now we'll have to try it again. Mic check on YouTube. Mic check on YouTube. They said nobody's on YouTube, buddy. Don't worry about it. Nobody's watching it. All right, now let's get my stuff back up. So we can do the Declaration of Independence on one, do due process on the other. Declaration. What's up, everybody? What's up? What states are we from? What states are we from? Declaration of Independence. What's up, everybody? What's up? What's up? All right, so we got the Declaration of Independence. Then we're going to do due process. Due process. All right, due process, due process. Cool, cool, cool. All right, what's up, everybody? What's up? Let's see if they send it to some people now. Probably not. All right. Let's watch all the followers come pouring in. Right to travel. What's up, everybody? What's up? What's up? What's up? All right, let's see here. There we go. There we go. What's up, everybody? Let's see. There we go. Constitution. The Constitution. What's up, everybody? What's up? What's up, everybody? What's up, everybody? What states are we from? What states are we from? Let's see here. The right to travel. Do we have the right to travel, everybody? What do they call it? They got another name for it. They have the appropriate name for it. Let me see if I can find it. Let me see. I think they call it public way. What's that, page 114? Let's see. I forgot what it's called. Oh well. What's up, everybody? What's up? What's up? What states are we from? Michigan. No. What was I going to look up? I was going to look up something. Let's see. Oh, I'm going to do my thing again. All right. So we're going to do what we do every day. Common way. I think it may be common way. Probably not. I got it in the book. I just can't remember the exact verbiage. If I search way, it'll show a million words that I won't be able to sift through. Movement upon the common ways. There we go. Look at that. I found it. You have movement. You have the right to movement upon the common ways. That's what it's called. You do not have the right to travel. Travel is a term for a merchant. They say there's different types of merchants. You got a merchant that travels, you got a merchant that buys and sells, you got a merchant that, yeah, all of those things are commercial terms. So technically, no, we don't have the right to travel because traveling is a commercial term. I forgot about that. What's up? Anybody on YouTube? Nope, 4 people on YouTube. What's up, YouTube? Oh, they left real quick. They say, "Yep, let's get out of here." Oh, he looked over. What states are we from? California's in the house. Let's go. Yeah, so they said we got the right. to movement upon the common way. Move along the common way. Common ways. Okay, that's not the same sentence. But it is. It's called the common ways. Okay, there we go. So we're going to have to look up what the word way means in a law dictionary. And if you're on the Patreon, I got 26 of them. Get to work. Today I was looking up the word abatement. Abatement. Let me pull it up because I don't want to get it wrong. Abatement is a very important word. If you're a paperwork people, like it's these people. I don't want to talk about them, but what dictionary I need? Okay, well, abatement is a if you're a paperwork warrior, you need to learn about abatements. Abatement is very important. And abatement. Let me see if it'll pull up. Well, it's got to pull up, but. What's up, everybody? Let me read some stuff. I'm trying to see if anybody else comes on, but I guess that's not how that works here. They said we're not showing it to nobody else. Yeah, good luck. That's what you got, buddy. All right, yeah, abatement. An abatement, there's a bunch of types of abatements, but an abatement is a type of pleading. Okay, an abatement is the overthrow of a court action in consequence of some error committed in bringing in or conducting it when the plaintiff is not forever barred from bringing another action. They said pleas in abatement. Plea is a type of court action. That's how you respond to a complaint. Will be considered as relating to the jurisdiction of the court. So these are types of abatement. So you can have an abatement to the jurisdiction of the court, to the person of the plaintiff, to that of the defendant, to the writ, to the qualities of such pleas, to the form of such pleas, and to the affidavit of truth of pleas in abatement. And then they got a whole bunch of law books that they got about abatement. See, that's what I like about law dictionaries is the dictionary is not the thing that's significant. For every word, there are a million books about that word, or there are volumes of books concerning one word, right? So they say, I don't know all these books, but I know there's this guy named Joseph Chitty. That's really his name. CH. He's got books on abatement. Let's see. I think his name is John Coleman. He's got a digest on abatement. They got civil pleas. Some guy named Archie or Arch has a book about civil pleas, and then I'm sure they'll have a chapter on abatement, right? Bacon. I think his name is Matthew Bacon, spelt Bacon. He has an abridgment about all topics of law, but they're in alphabetical order. So one of the first chapters would be on abatement, right? So for every one word, there are volumes of pages concerning that one word, right? So the law dictionary is not enough. It'll tell you where to start learning about a word. But all throughout history, somebody has made a comment about this type of action named an abatement, right? And then you get lower and lower. They got Massachusetts cases about abatement. They got Pennsylvania, Mississippi. No, misnomer. Yeah, so they got a bunch of books on abatement, right? But yeah, that's on abatement. So if you love paperwork, you love writing pleadings, and there are YouTube videos. You can, you can learn about pleadings through YouTube videos. And I'm sure there are books just on pleadings. I I believe I have 2 books on the Patreon about common law pleadings. If I don't, somebody remind me, I'll find it and upload them. But I want to read this real quick. No, I can't read that. That's about the 16th Amendment. You can't talk about that on the internet. Let's see here. They said the very purpose of a Bill of Rights was to withdraw certain subjects from political controversy, to place them beyond the reach of majorities and officials. One's right to life, liberty, and property may not be submitted to vote. You can't vote them away. They said they depend on the outcome of no elections, right? So it should be virtually irrelevant who's the president, who's the governor, who's this, who's that, because they have a responsibility regardless of their political affiliations and their political leanings. If you're a Democrat, if you're a Republican, and none of that is concerning the law. The law is clear. You are not allowed to take away people's life, liberty, or property because you put a certain guy in office and you think that that will give him the power to write things magically, biasly for one specific group of people. They said the purpose of a Bill of Rights is that it is beyond the reach of political conversation. They say it doesn't matter who you voted for or why you voted for him. When that dude takes an oath to the United States Constitution, or when that dude takes an oath to the federal Constitution, he has a job to do regardless. He's bound by the law regardless of how he feels about a subject. So they said one's right to life, liberty, and property cannot be submitted to a vote. They depend on the outcome of no elections. All right, Declaration of Independence. Let's see here. I didn't read these yesterday. Who is this? This is the Supreme Court of New York. They said, we have already seen that upon the Declaration of Independence in 1776, the people of each state became sovereign. They said that after the Civil War. That's what I love about these cases, because it's all about a time frame. What's the time frame? From 510 BC to 1215. You got this thing called the Common Law of England. Okay. Then from 1215 up until 1776, well, 1607, you got this fake commercial paperwork life that comes in, right? From 1215 to 1607, right? Then you got these people that show up on a place they now call Virginia, and from 1607 up until 1776, they're still battling it out just on another continent now. All right. And then you get to 1776 and they say, yep, we already seen that upon the Declaration of Independence in 1776, the people of each state became sovereign. See, we don't get the significance of that. Do you know that on July 4th, 1776, every major country on the planet, the people were never considered sovereign? Everybody was under some type of monarchy. Everybody was under some type of king or some type of dictatorship for a long time. You look up the history of France. They've been under a monarchy forever. England, forever. Germany, forever. Japan, forever. They've been under all of Asia, emperor after emperor after emperor after emperor. Okay, you get to this thing called 1776, and they say the people are yeah, we don't do that people are sovereign stuff. The world had never seen it. I told y'all they got in the Constitution this thing called a Republican form of government. Okay, well, they didn't know what that meant. They said the preachers of the day had to go back to the first 10 books of the Bible to learn what a republican form of. They had been under a monarchy their entire life, their entire existence. Everybody they knew was under the king, under a king. They said, okay, yeah, well, y'all talking about declaring independence or whatever. So who are we going to be under after that? They say, yeah, make George Washington the king. They said, no, 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 no. We're doing this thing called a republican form of government. They said, no, what's that? And the preachers of the day had to show, okay, well, these people called the Anglos and the Saxons, our ancestors say they trace their history back to the people of Moses. And they had this thing in their day called the Hebrew Commonwealth. In the Hebrew Commonwealth, you got the people of God from Moses to Joshua to the book of Judges, and all of the principles that they had concerning the law. We're going to be inhabiting those. We are going to be practicing those. So they said this thing called a grand jury. Yeah, it's time for, yep, y'all gonna have to start doing it for real now, right? They said this thing called a trial by jury. Yeah, y'all gonna have to start doing it for real now. And these were all the things that led up to the July 4th, 1776. So they say, yeah, the Supreme Court of New York said, yeah, we already seen that upon the Declaration of Independence in 1776, the people of each state became sovereign. The Supreme Court of New York said, yeah, upon the adoption of the Declaration of Independence, New York became a nation. A what? A nation. They said New York is its own thing as of 1776. They said upon the adoption of the Declaration of Independence, New York became a nation, and with other sovereign rights, the right of preemption devolved upon it as the successor of the crown. And you know, I already read cases about this all the time. Okay, the people of New York are successors to the former sovereign. What do you mean they're successors to the former sovereign? Remember, this had never been done in thousands of years, y'all. Even in the Native American tribes, they weren't. They were under some chief, somebody. They didn't say the people were sovereign. They said, upon the adoption, yada, yada, yada. Yeah, this right of preemption devolved upon it as the successor of the crown. Alabama said, well, yada, 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 yada. They said liberty is an unalienable right, and it is an endowment of the creator. They're citing Thomas Jefferson and saying, okay, well, the God who gave us life gave us liberty at the same time. They said government exists to secure that right because liberty is a gift from God or gift of God. It must be exercised in conformity with the laws of nature and of nature's God. They said the natural liberty of mankind consists properly in a power of acting as one thinks fit. Ooh, don't tell them that. Without any restraint or control, unless by the laws of nature. Say injured party. They said the human as a dependent creature is not at liberty to redefine reality. Ooh, that's nasty. What year was this case? 2015. Let's go. They said the human as a dependent creature is not at liberty to redefine reality. They say you can't just write something and call it a crime where there's no injured party. Who told you you could do that? You can't redefine reality. They said the Declaration of Independence states that a human is bound to recognize the rights to life, liberty, and the pursuit of happiness, and as that is recognized as endowed by God. Those rights are not subject to a redefinition that rejects the natural order God has created. In 2015, bro, this is the Supreme Court of Alabama. You on the Patreon? Go to just search the Declaration of Independence. It'll say Declaration of Independence Part 2. They said this night Thomas, they citing Thomas Jefferson in 2015, y'all. All right, who is this? This is Dade County. Is this Florida? Come on, Florida. I didn't realize this, but this is the 250th year of the country. Yeah, this is Supreme Court of Florida. All right, let's see what the Supreme Court of Florida say. All right, now they say this concept of God has been and is so interwoven into every aspect of American institutions that to attack this concept is to threaten the very fiber of our existence of a nation. They do it every day. Yeah, they got these things called universities now. They create these people called atheists. They said it should be, and they worship scholasticism. What's that? Fake paperwork. They said it should be clearly understood that this was not a movement for the separation of state from Christianity. We talked about it yesterday. Who were they fighting in the Revolutionary War? Who were they trying to separate from? Right? They said this is not a separation of state from Christianity. See, this flies in the face of everybody who gets on the news and say, "Oh, well, the separation of church means that you can't you can't have biblical principles in the common." Okay, well, that would be incorrect. The Supreme Court of Florida would disagree with you. All right, so they say this should clearly be understood. Nobody should be debating this. They said this is not a movement for the separation of state from Christianity, but specifically a separation of church and state. What church? Which one? Yeah, they said this thing called the Roman Catholic Church. That's the one we're separating from. Not Christianity. Right? We talked about it yesterday. They said we didn't have a problem with laws. We had a problem with government not obeying the law. I'm finna tell you, they got it all right here, buddy. You got it all right here. I'm finna read it to you. So they said, yeah, this is not a separation from state from Christianity, but specifically a separation of church and state. They said Christianity entered into the whole warp and woof of our governmental fabric. I told you that common law nasty, boys. They said many of the statesmen of this country treated Christianity as part of the law of the land. So they didn't say we're separate. That's not what separation of church and state means. It means separation from ecclesiastical law and state and government. So they said by the Declaration of Independence, the colonists asserted that certain unalienable rights were endowed by the Creator. They said, what are y'all talking about? This is as easy as reading the Declaration of Independence. They said the supreme judge of the world for the rectitude of our intentions was done in the name of the most holy and undivided Trinity. This is the Supreme Court of Florida, y'all. Not in 1856. They said that in the 1960s. The colony of Georgia was not an exception. In the charter granted to the trustees for establishing the colony of Georgia in America, there shall be a liberty of conscience allowed in the worship of God to all persons within the province, and that all such persons, and they say this in quotes, so you know I'm not making this up, except papists. Who's the papist? People who worship the papacy. Well, what's the papacy? We just talked about it yesterday. Who were they fighting in the Revolutionary War? Oh, y'all not gonna say it. Okay. All right. Well, they said these people called the papist of the papacy. Remember, they said it. Okay, yeah, this is not a separation from Christianity and state. The Supreme Court of Florida said that. They said this is a separation of church and state. Which one? They was very specific. We talked about it yesterday. They said, yeah, this thing called the Roman Catholic religion has taken over Quebec and abolished English laws. If you're on the Patreon, go to it's a bunch of cases. One from the Supreme Court of New York, Supreme Court of New York, Supreme Court of Alabama. They said I forgot where I was at. Yeah, okay, who is this? This is I don't know who this is no more. Georgia or Florida. No, we're on Georgia. So the Supreme Court of Georgia said the colony of Georgia was not an exception. In the charter granted to the trustees for establishing the colony of Georgia in America, there shall be a liberty of conscience allowed in the worship of God to all persons in the province, and that all such persons except the papacy, except what they call papist. You should change that P to an R, and it would be the exact same people. uh, I'm gonna get this live stream flagged. They said shall have a free exercise of religion. They said all but one group of people will have a free exercise of religion in this country or in this colony at the time. Who were they fighting in the Revolutionary War, y'all? Y'all not gonna answer, but I'm gonna tell you. The Roman Catholic religion. They said it. They said it 4 times. The United States Continental Congress said in 1774, the reason we are declaring independence is because of this thing called the Quebec Act. Go Google it. The Quebec Act the Quebec Act was the Roman Catholic Church invading because Quebec was an English colony. And so the Roman Catholic Church invaded British Parliament in England, and they started taking over Quebec in Canada. And as a result, this is all in the Declaration of Independence. They said, for abolishing a free system of English laws in a neighboring province, establishing therein an arbitrary government. That's the one we got today. And enlarging its boundaries as so to render it at once an example and fit instrument for introducing the same absolute rule into these colonies. They said, yeah, these boys called the Roman Catholic Church took over Quebec, and they write fake laws. They set up an arbitrary government and abolished common law due process, which they moved to Quebec because they were guaranteed that they would have English laws, that they would have the Magna Carta, that they would have a trial by jury, that they would have due process where you couldn't take away people's life, liberty, or property without being tried by the peers of your vicinage. Okay, well, this thing called the Quebec Act in 1774, when they invaded Parliament in England, they took that all away in Quebec. So they say, yeah, they abolished the free system of English laws in a neighboring province and established therein an arbitrary government. They started sending the black robes over there. They say, "Yep, time to suit up, boy. We got to get bread." They said, "No, we don't do that common law of England stuff. No, no, no. Don't worry. We're very educated. We're experts. We went to school. They trained us all about law. Don't worry. You got a real good judge here. You don't want they're not as educated. You don't want them. Don't waste their time. They got farms and stuff. How do you plea? How do I plea? You don't have jurisdiction. Right. We don't do no challenging jurisdiction here. Yeah, we don't do due process. Oh, yuck." So they say, yeah, they took over. And so you get to this thing called Georgia, or the colony of Georgia. They say, yeah. Everybody shall have a liberty of conscience to worship God. Everybody in this province, except one group of people. Yeah, them Roman papists, the people who acknowledge the spiritual supremacy of the Pope. I'm gonna read it in just a minute to you. They said everybody else shall have a free exercise of religion. They said they knew something we didn't know today. The Supreme Court of Georgia said many of the statesmen of this country treated Christianity as part of the law of the land. Who was it? I thought I read it twice, but I guess I didn't. Yeah. Who is this? Florida. Supreme Court of Florida said many of the statesmen of this country treated Christianity as part of the law of the land. You get to Georgia, they say the same thing. Yeah, many of the people of this country, many of the statesmen of this country treated Christianity as part of the law of the land. They said the issue was not Christianity. The same way the issue was not the law. The issue was the government, and then the issue was a church trying to enforce its ceremony onto the people and deny them the liberty of conscience. See, they were mature enough to say, well, you don't have to believe everything that we believe concerning Christianity, but we can't impose it on you, and you can't impose it on us. They said when they got to Canada and established this thing called the Quebec Act, they imposed it on them. They said, no, we're going to hand out citations, and these citations come from the ecclesiastical order. That's what I didn't talk about yesterday. What's a citation? I think I did talk about it. For those who got the book, let's look up the word citation. Okay, a citation is a summons to appear into a spiritual court. Uh-oh. They said this thing called the ecclesiastical courts proceed according to the course of civil and canon laws. They said, yeah. Everybody has the freedom to practice religion here except these papists, except the people who acknowledge the spiritual supremacy of the Roman Catholic Church. So they said this thing called the citation, the ecclesiastical courts proceed according to the course of civil and canon laws by citation. And then they give you a little example. They said every archbishop. Okay, well, what's an archbishop? Where they come from? Oh, that only comes from one type of church. Uh-oh. They said every archbishop may cite any person dwelling in a bishop's diocese within his province for heresy. They say you break these fake spiritual laws and we'll issue a citation. They said that's what was going on in the province of Quebec, and they started doing it in the colonies. They said a citation is an act by which a person is summoned or cited. They said ecclesiastical, probate, and divorce courts call a defendant to respond before them. Yeah, that's called witchcraft in the Bible. You're not supposed to be summoning nothing. So they say it again. Let me see. I got another one. Let me see. Let me see. Okay, they said these people called the Jesuits under the pretended jurisdiction of Rome. This is during the time. This is in the 1730s, 1740s, 1750s. They said these people called the Jesuits. Who are the Jesuits? Oh, yeah, they come from the Roman Catholic Church. They said under the pretended, you know what pretended means. You don't need Black's Law Dictionary. What pretended mean? It mean fake. It means fake jurisdiction of Rome. And they said under a pretended act of parliament. Okay, well, what's parliament in England? They're the legislator. They're the people who write the statutes, the codes, the regulations, the ordinances. They said it was pretended. What pretended mean? It mean fake. That's what it mean. It mean fake laws. Somebody say fake laws. They say, yeah, these Jesuits who were born in the King's Dominion, they were born in England, but they were ordained from somewhere else. They said under a pretended act of parliament. They said they wrote a fake law to let them start taking over the books, start taking over the law. They just magically start writing laws now. And they did that under the pretended jurisdiction of Rome and pretended acts of parliament and took over Quebec. And they're still dealing with it today, y'all. You go look at Canada. All they do is complain about their government. They said these Jesuits turned the books of the law, the proceedings of the court of justice, and it was declared to be enforced by them. By them, they're not. Never mind. All right, so you get to Georgia, they say, yeah, everybody except these guys have the free exercise of religion because their church, their religion imposes things that presupposes to take away our rights, our life, liberty, and property without due process, without due course of law, without the law of the land. You study this thing called the law of the land. The Supreme Court of North Dakota said even God in the Bible, in the book of Genesis, had due process of law. He said, Adam, where are you? He gave him an opportunity for notice and an opportunity to be heard before he prescribed the punishment. He said, Adam, where are you? Did you eat from the tree that I commanded you not to eat from? And Adam said, man, that chick you gave me, right? They said, the hoe over there. No, I'm just playing. She gave me the fruit and I ate it. Okay, yeah, I asked you if she ate it. I asked you if you ate it. He said, yeah, y'all gotta go. Right? He followed due process. Okay, so don't say you come in the name of religion and church and then you deny people their life, liberty, or property without them being heard by the peers of their vicinage, a trial by jury, right? So they say, yeah, everybody but these papists. Yeah, y'all can worship whoever, whatever. Do what you got to do. Just don't put your hands on nobody. Don't take nobody's stuff. Don't damage nobody's property. They said that's the common law right there. It's real simple. They said you didn't need books for it. They got this thing called the Ten Commandments. You didn't need books. They say the common law is unwritten. They say, yeah, they already wrote it. This dude called Moses, he wrote it down one time. Yeah, don't put your hands on nobody. Don't steal nothing. Don't damage nobody's property. The end. Yeah, that's the common law. They said everything else they got require fake pieces of paper. All right. Let me go to the Constitution. Then we're going to go to, yeah, here we go. All right. So this is, I talk about this all the time. This is New York. This is the story of New York. So they're talking about how New York became a state and how it all developed, right? But in this excerpt I got, they say New York, like Massachusetts, seemed at all times determined to suppress the Romish church. Somebody say Romish church. They said that's why they don't show my live to nobody. They say in an act passed in the beginning of the last century, 1600s, it was declared that every Jesuit, we just talked about them, right? And popish priests, Georgia just said it, right? They said the papist, all right, who should continue in the colony, the New York and Massachusetts colony, after a given day should be condemned to perpetual imprisonment. They said, no, we heard what y'all doing in Canada. No, we're not with that. And if he broke out of prison or escaped and was retaken, you had to get rid of him. That's what they said. I wasn't there. They said, I can't read exactly how it say it, but they said you had to get rid of them. They said, no, we can't have them. Because you really realize what they're doing and the reason they had to get rid of them? Yeah. I want you to Google the priest of Baal and the priest of Baal sacrifices, and you'll see these are the exact same people and why they had to get rid of them. And they said so little was the spirit of toleration and the rights of conscience understood at a much later period that one of her historians a half a century later said that, yep, we still have a spirit of little toleration. And then they said, okay, well, at the Constitution of New York in 1777, they required all persons naturalized by the state to take an oath of abjuration of all foreign allegiance and subjection in all matters ecclesiastical. There you go. What's that? Separation of church and state, as well as civil. They said this was doubtless, they said this is not up for debate. This is not an opinion. This was doubtless intended to exclude all Catholics who acknowledge the spiritual supremacy of the Pope. So who were they fighting in the Revolutionary War? This is 1777. The war didn't end until 1783. They said this was doubtless intended to exclude all Catholics who acknowledge the spiritual supremacy of the Pope. So what we just read, worship of God to all persons in the province except except who? Yeah, the papist. They say everybody else got a free exercise of religion. You want to be Muslim? Go be Muslim, bro. Do your thing. Don't put your hands on nobody, but go be Muslim. You want to be, whatever they worship in Asia, go do your thing, bro. Just don't put your hands on nobody. They said everybody but. Everybody but this one group. No, we beefing with them right now. We're not with this. All right. They said many of the statesmen of this country treated Christianity as part of the law of the land. They said this stuff was serious. Due process. Let me go to my favorite constitutional arguments, and then we will go to due process. Somebody say due process. Due process. All right. Constitutional. Oh, I forgot my YouTube comments. Just messed all that up. All right, let's try that again. All right, do constitutional arguments, then due process. Let me clear up some tabs here. Okay, we got constitutional interpretation. I forgot. I don't know what that means, but where's my other one? You never find stuff when you need it. Let's see. I only read it every other day. Boom. There we go. All right. Here we go. All right. So, Supreme Court Justice Joseph Story said that it can hardly be doubted that this thing called the Constitution is predicated upon the existence of the common law. They said this has not been denied by any person who has maturely weighed the subject and will abundantly appear upon the slightest examination. They say, oh, yeah, you read, oh, yeah, common law. That's what they got. They said the trial of all crimes shall be by jury. They said no one can doubt that for the explanation of that term and for the mode of conducting trials by jury, recourse must be had to the common law. They said this thing called in the Constitution, judicial power shall extend to all cases in law. Okay, he said this is inexplicable. What that mean? It is unexplainable without reference to the common law. They said, what is a writ of habeas corpus? They said the common law alone furnishes the true answer. They said the existence of the common law is not only supposed by the Constitution, but it is appealed to for the construction and interpretation of its powers. They say, you want to know the powers in the Constitution? Oh, yeah, you have to go back to the common law. That's where it's at. That's how you're going to understand it. You got to understand, to these people, the Constitution is on one page. It's on like 7 little paragraphs. That's it. They say you can't understand what everything mean in the Constitution. You're gonna have to go back to this thing called the common law to know what it means. They said, what are crimes and offenses against the United States? They said recourse must be laid to the principles of the common law. He said we resort to the rails of the common law to give them an interpretation. They said, for instance, Congress has provided for the punishment of murder, manslaughter, perjury, but it has nowhere defined these crimes. I love that he says that because that dude said it. This dude's one of the first Supreme Court justices. And so they'll say today, oh, well, the legislator defines what a crime is. Nope. They said you can provide punishment, you can't define. It's already been defined. You want to know what a crime is, you're going to have to go back to the common law to know what a crime is here. They say, yeah, we're a new country, but the law's old. You're going to have to go way back. They said Christianity is part of common law. You want to know what a crime is, you're going to have to go to the 10 Commandments. That's what a crime is. They say you break one of these 10, yeah, you committed a crime. Mm-hmm. They said, well, yeah, Congress, the legislator, has provided for the punishment of murder, manslaughter, perjury, but it has nowhere defined these crimes. They said, so let no doubt ever be entertained on this thing called trials. If you want to know what a trial is supposed to look like in the Constitution, the explanation of them must be sought and exclusively governed by the common law. They say you can't have no other type of trials because the thing you call a trial has to be governed by this thing called the common law. They say you want to know what a trial is supposed to look like in America? Okay, well, you got to go back to this thing called the common law. He said upon any other supposition, this is what attorneys do. They do any other supposition. That's what their job is. They say, oh, we don't do the common law no more. The Constitution is a living document. So that means that we make the Constitution mean whatever we want it to mean. No, you can't do that. So that dude said, upon any other supposition on what you think a trial is supposed to look like in this country, the judicial power would be left to the arbitrary pleasure of a judge. Okay, well, what we dealing with in 2026? The arbitrary pleasures of the judge to an uncontrollable and undefined discretion. Yeah, they said the black robes. Yeah, that's what they do. Uncontrollable and undefined discretion. I'm talking about, it's crazy, y'all. I read all these cases. These cases say, well, an inferior court can't imprison or fine people. Okay, well, every court outside of the Supreme Court is an inferior court. They're never supposed to be imprisoning or fining people outside of an actual injured party. They said, whatever you think is the dread of the common law, such a despotic power could hardly be deemed more desirable. He said, whatever you think is too difficult, too old timey, this is what these attorneys say. Oh, well, they got outdated principles. Outdated? No, the outdated thing is the thing that restrains you. And that's the thing y'all don't like. So y'all say it's outdated and say that this new way is progressive. No, they said whatever you think is the dread of the common law, whatever you think is the outdated principles. Okay, well, leaving it in the hands of one guy in a black robe. Okay, who are the guys in the black robes? Go Google it. Go Google if the priest of Baal wore black robes. Go Google if the prophets of Baal had black robes. They said these people come from the pretended jurisdiction of Rome. They said they're under pretended acts of parliament. These are fake laws. These aren't laws. The law is old. It ain't new. They don't come out when there's no such thing as a new law. I got a law book that says that. They said that the law book was on laws in the medieval times. They say, yeah, even now, there's no such thing as a new law. You want to go back in time, you want to know the law. They say no such thing as a new law. They get on the news every day and say, oh, well, today we got a new law. Starting this day, if you don't do this, then we'll presuppose a punishment before a trial's happened. They say anybody caught doing this will receive a fine magically. No trial, no due process. They say we will tow your car. Don't worry about it. We don't do that common law stuff here, sweetie. Right? So they said, yeah, whatever you think is the dread of the common law, the guys in the black robes are worse. They said there are great variety of cases arising under the laws of the United States, which were unless by the adoption of the common law. He said nothing is more clear. He said this stuff is not up for debate, y'all. The interpretation and exercise of the vested jurisdiction of the courts must be governed exclusively by the common law. Say the common law. I forgot about this. Who is this? This is Illinois. Let me add this to Illinois. I think this is Illinois. Yep, I got it on there already. All right. The Supreme Court of Illinois said the Eighth Amendment is based directly. There you go. They said, oh, you're telling the truth. Can't do that. They said the Eighth Amendment is based directly on Article 1, Section 9 of the Virginia Declaration of Rights. You would think they said, oh, well, it's based on the United States Constitution. They said, no, we're not talking about the United States Constitution right now, sweetie. They said they got that from this thing called the Virginia, because these attorneys will say, oh, well, no, all the state constitutions are based on the federal constitution. Well, Virginia had a constitution and a Bill of Rights before there was such thing as a United States Constitution, before there was such thing as a federal constitution. So when you get to this thing called Illinois, who came way, way, way after, they say, yeah, we didn't get this from the Eighth Amendment. We got this from Virginia, because the United States Constitution is based on the original 13 states Constitution. They said South Carolina had a constitution. They had a government. They had a Bill of Rights before there was such thing as a federal Bill of Rights. They said the federal Bill of Rights is concerning federal things. All right. So they said this Eighth Amendment is based on Article 1, Section 9 of the Virginia Declaration of Rights, which adopted verbatim language from the English Bill of Rights in 1689. And then they say, okay, well, this thing in the Eighth Amendment and the Virginia Declaration of Rights is the language found in the Magna Carta. So they say, yeah, we got this from law is old. They say you got to go way, 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 way back. If you want to learn about the Eighth Amendment, they say you can start in Virginia. Yeah, go there. And then you're going to have to jump way back to the year 1215. All the time. It's a law book on constitutional law. They said, okay, well, Constitution, state or federal, must be construed with reference to the common law. They said the federal and state constitutions did not repudiate the established common law. What does repudiate mean? Repudiate. Deny the truth or validity of the established common law. They said the common law of England was adopted by the several states. They said in interpreting the federal constitution, recourse is still to be had in aid of the common law of England. It is said that without reference to this common law, the language of the federal constitution could not be understood. There you go. Don't believe me. They said that this is due to the fact that this instrument and plan of government, they said the Constitution and the government were founded on the common law as established in England at the time of the Revolution. They said the Bill of Rights is taken explicitly from the common law and must be construed in reference to the latter. There you go. They said specifically the United States Supreme Court has taken the common law into consideration in construing the Fourth Amendment. The Supreme Court of Florida said it is not only proper but necessary that reference be made to the principles of the common law in ascertaining the meaning of the terms in a constitution. The Supreme Court of Ohio said it is to the common law that we must look for legal definitions and judicial ideas in interpreting the federal and state constitutions. What was this? California said the common law formed the basis of almost every right secured and every remedy provided in the California Constitution. Due process. Let me clear some tabs. Somebody say due process. Let's see. We're going to go to North Dakota. Here we go. The Supreme Court of North Dakota said, okay, well, due process of law means law in its regular course of administration through the courts of justice. They said notice and an opportunity to be heard before the court whenever life, liberty, or title, or possession, or property are involved. They said they can't just be towing people's stuff before a court case has been had. They do it every day. They said the laws of God and man both give the party an opportunity to make his defense if he has any. Even God himself. Oh, they said God is a he, y'all. Uh-oh. No, I'm just being silly. Even God himself did not pass sentence upon Adam before he was called upon to make his defense. Adam, where are you? Did you eat from the tree where I commanded you should not eat? He gave the same question to Eve also. They said a party shall have an opportunity to be heard in his defense before his property is condemned. They don't do that any day of the week. They said you're supposed to have an opportunity to be heard in your defense before property is condemned. Before they tow the car, when there's no injured party, you're supposed to have a court case prescribing the punishment. You're not allowed to prescribe the punishment before you've been heard in your defense. They said God didn't even kick Adam out of the garden until he asked him to defend himself. What you got to say? Did you eat where I told you not to eat? Right? He said, this is a rule as old as the law. Remember, they just cited the book of Genesis. They said that's where the law at. They said no one should be personally bound until he has had his day in court. They said judgment without citation and an opportunity wants all the attributes of a judicial determination, and this is judicial usurpation and oppression. They do it every day. The Supreme Court of North Carolina said that though the lawmaking power can unquestionably create a municipal corporation and delegate legislative authority to it, it cannot clothe that creature, what creature? The municipal corporation, with power to do what the Constitution prohibits the creator from doing, which is what? Clothe the creature to do what the Constitution prohibits it from doing, taking life, liberty, or property without due process of law. Montana said, the Supreme Court of Montana said, okay, in this country, the power of the legislative departments is limited by written constitutions. They said the English doctrine of parliamentary omnipotence has no place in American institutions. What's parliamentary omnipotence? The Jesuits ordained by the pretended jurisdiction of Rome under a pretended act of parliament can write whatever they want in England now. Okay, that's parliamentary omnipotence. They said that don't have no place in Montana. They say you can't just write whatever. You're not supposed to be writing whatever, and it presupposes to take away your rights. They said it may affect They said if they do this, it may affect the rights of all persons alike, which deprives the citizen of his life, liberty, or property without due process of law. A hearing must be allowed to him at some stage in the proceeding against him. The Supreme Court of Alabama said the owner of property cannot be deprived of his property but by due course of law. They said these terms, law of the land, due process, and due course of law, mean the same thing. And they are found in the English charters and statutes and in our American constitutions, and they have the same meaning. Edward Cook said, by the law of the land and due course and process of law, by indictment means by indictment, which means a complaint by an injured party, or presentment of good and lawful men, by the writ original of the common law. Let's see, Ohio said, the Supreme Court of Ohio said, it is very obvious that everything is not therefore deemed to be law of the land or due course or process of law. It was against the enactment of new laws which ignored the proceedings according to the course of common law. The protected what is the according to the course of common law is the protecting shield of the Constitution. That's what the Supreme Court of Ohio said. They said an act of the legislator this is the Supreme Court of Illinois. The Supreme Court of Illinois said an act of the legislator is not the law of the land. That's what they want you to believe. They no lie. These attorneys tell me this straight to my face. They say, "Oh, well, because the legislator did it, it's constitutional." Come on now. Come on now. That's what they want you to believe. They want you to believe that, what did Montana say? That the legislator has parliamentary omnipotence, that they can do no wrong. Okay. Well, Illinois said, well, yeah, an act of the legislator is not the law of the land. That's not due process. A state cannot make anything due process of law by its own legislation declaring it to be so. They said an act of the legislator which transfers the property of one man to a tow truck driver without his consent is not a constitutional exercise of legislative power, because it deprives a man of his property without due process of law. This is the most important thing. They say this is what the Roman Catholic Church does. They deprive people of their life, liberty, or property without due process of law. The Bible says there's nothing new under the sun. They said they did it then, they doing it now. New Hampshire. We ain't never heard nobody from New Hampshire. They said certainly this thing called the legislator, or this thing called due process of law, does not mean any act which the assembly may choose to pass. They said this thing called the law of the land, within the meaning of the term as used in the Constitution of Michigan, is a law which hears before it condemns, which proceeds upon inquiry and then renders judgment after trial. The Supreme Court of Indiana said the guarantee of due process of law is to prevent the state government from exercising by any of its departments. What departments? The legislative, who writes fake laws, the executive, who polices fake laws, and then the judicial, who denies us a trial by jury because of these fake laws. They said this thing called due process of law is supposed to prevent the state from exercising by any of its departments an arbitrary and capricious power over persons or property. They say it again. This thing called the law of the land, or due process of law, cannot be taken to be the very act of legislation which wantonly deprives a person of his rights. There are rights in every free government which are beyond the control of the state. Minnesota, Supreme Court of Minnesota said, to give this due process clause any value, no person shall be deprived of any form or by any form, legislative or governmental action, a law which can extinguish the rights of property or compel their extinction without any legal proceedings whatsoever, comes directly in conflict with the Minnesota Constitution. They said that this thing called due process of law requires notice, hearing, and then judgment. They say again, just like they said it in all these other states, this thing called due process does not mean anything which the legislator may see fit to declare due process of law. There are certain fundamental rights which not even the legislator can disregard. They disregard it every day. So they said this thing called due process is notice before judgment in all judicial proceedings. They say this thing called police power expressed in an ordinance is subordinate to the Minnesota Constitution. They said that's based on the Minnesota Constitution, Article 1, Section 7. Minnesota again said that Section 2, Article 1 of our Constitution says no member of this state shall be deprived of any of the rights, privileges secured to any citizen unless by the law of the land or the judgment of his peers. They say, okay, this no person shall be deprived of life, liberty, or property without due process of law. Oh, they say it twice in the same Constitution. Okay, they should never be doing it. They said by due process of law does not mean what it don't mean. The act of the legislator. They said, who's the problem here? All these states we reading. They said we got one common denominator. They think they can write whatever they want, and they cannot. And this is another thing that I noticed. So when they want to publish or not publish, when they want to publicize a new law, they'll have some fake attorney get on. Let's just use TikTok, for example. They'll have a news, a NBC, a ABC. They'll get on the news and say, okay, well, Texas came out with a new law and starting whatever. Okay, well, if y'all don't do this, then they're going to start, hypothetically, I'm just making up stuff. They're going to start towing cars and giving out fines. They'll just get on the internet or get on TV and get on cable and just presuppose that, okay, well, they passed a new law. And starting whatever day, if you don't have this thing done, if you don't do this, then punishment will magically be prescribed to you. And they say, no, we don't have to go to court over the issue. They say, we're going to tow it, or it's going to cost this much. It's going to be a fine. Yeah, all of that is violation of due process. Like, they want due process to be more complicated than that. No, it's real simple. Due process is real simple. You cannot write things that presuppose a punishment. You can't prescribe, the legislator can't prescribe punishment. Like the Supreme Court in New York said, okay, well, you can't declare anybody guilty of a crime. That's not your job. Your job is to write things that will protect rights. They write things that do the opposite of protecting rights. They say, yeah, we're going to do the opposite of that. Due process. Not here, buddy. Yeah, you're going to magically owe us if you violate this fake rule that nobody can keep up with. They say, yeah, property taxes are just going to go up every year until you won't be able to afford it. And then once you don't be able to afford it, oh, we're magically going to sell it and get a commission from the tax sale. We're magically going to tow it. And then you're going to have to pay the tow truck company and you're going to have to pay the courts to deal with the issue. They just magically prescribe punishment, y'all. Magically. No due process. Forget about it. Right? So Minnesota said, okay, well, this thing called due process does not mean any act of the legislator. Right? So they'll get on the news, they'll get on TikTok, they'll say, oh, well, starting this day, new law. If you don't do this magical thing, well, then you'll be subject to fines and or impoundment or arrested or whatever. They do this every day. Y'all know I'm telling the truth. And then because we don't scrutinize and follow that law, well, they didn't really publish it as law because there's a certain way you have to enact. They have to have an enacting clause. They have to have a whole bunch of stuff to verify that it's actually law. So they'll write things, like I say all the time, they'll put things in the code that they didn't actually write in the statutes. So they'll write fake laws in that code. And because we believe the code is the law, okay, well, if we don't scrutinize it and verify it all the way back to the state constitution or federal constitution, well, we magically believe it's law. Not maybe you, I'm saying the population as a whole will magically, well, they put it on the news. It must be true. Okay, well, the news is not official publication of the law. We read it all night. Okay, this thing. Yeah, they said notice before judgment and all judicial proceedings. Well, they'll just get on the news and say, oh, well, a new law has been passed. And then they'll put it in the code, but they won't actually enact it as real law in the statutes. They won't give it an enacting clause. They'll write it. It won't be verified by anything. And then if you don't do that magical thing, then they'll fine you or they'll ticket you or they'll take your stuff or put you in handcuffs. No law. All right. So Minnesota say, yeah, you can't just write something and call it due process because you wrote it. No. They said where rights or property are admitted to exist, the legislator cannot say that they shall exist no longer. They do it every day. They said, this is Maine. The Supreme Court of Maine said the legislator has no power to change, qualify, abridge, or encumber with conditions or restrictions or any terms whatever. They said this thing called the law of the land, as used in the Maine Constitution based on Article 1, Section 6, and Section 8 of the Maine Constitution, does not mean an act of the legislator. So they say just because they wrote it don't mean it's law. They want you to believe it's law. They're going to get their attorneys that, oh, well, you got to obey the law, magical law. No, they passed it. They passed it. Okay, well, that don't make it law. Because who are the real judges? That's what they really deny. That's the whole issue of the Declaration of Independence, is that they were passing these fake laws and then they wouldn't let it get to the jury where they would say, okay, well, this is ridiculous. We're not convicting this dude. Right? So they said, oh, yeah, we got to send the black robes out. And then we'll never get them before the jury. And then some dude would magically get convicted and he would go back to the community and say, well, y'all didn't get a summons to be on the jury today? I said, no, nobody came to us. Okay, so you saw that the sheriff wasn't doing his job. Nobody was doing their job to protect the people. I told y'all, go, I don't know if it's still free on YouTube, but Robin Hood by Russell Crowe. Okay, well, it's a fictitious movie, but they go over all of this stuff during the time period of the Magna Carta. Somebody say Robin Hood by Russell Crowe is on YouTube for free right now. You watch that movie, they got the sheriff in there. These are the common law sheriffs we thought we had. You see all of the violations of due process, being taxed without consent, the sheriff's not protecting the people like he's supposed to, all of this stuff. They said that's how they ended up getting the Magna Carta. They had the whole King John at the point of a sword and say, hey, yeah, y'all wildin', you got to sign this or we're going to bang it out right here because this is ridiculous. They said this thing called the law of the land does not mean an act of the legislator. If such was true, then this branch of government could at any time, they do at any time, take away life, liberty, property, and privilege without trial by jury. That's what they do every day. They said this thing called the law of the land, quoted in our Maine Constitution, is the exact same construction of Chapter 29 of the Magna Carta. They said this thing has been borrowed and incorporated into the federal constitution and most of the constitutions of the individual states. They said Edward Cook said no man shall be deceased unless it be by the lawful judgment, that is a verdict of equals, or by the law of the land, which is by due course and process of law. Again, Massachusetts say the same thing, y'all. They say, yep, this thing called the law of the land does not mean that things can be altered by the legislator intended to prohibit the making of any law impairing the ancient rights. They say anything intended to prohibit the making of any law which is impairing the ancient rights and liberties of the subject, because they're citing Old English, would be nugatory and void. New York, Supreme Court of New York said, yep, we said the same thing. Beating a dead horse. Annoying. Due process, due process, due process. Yeah, that's the only thing we got. Well, who protects us from the government? Oh, I can't say that. They'll flag the live stream. Let me stop. Right? You go to court every day and it's the government against you. It's the police officer, it's the legislator, it's the attorney, and the judicial branch against you. And everybody acts like that's okay. That's not a violation of the separation of powers. In any other arena, that would be called unfair. But here, oh, well, you better do what the government says. You better just comply. Yada, yada, yada. They said, New York said, okay, to say that this thing called the law of the land or the due process of law may mean the very act of legislation which deprives the citizen of his rights, privileges, property, leads to a simple absurdity. They said the Constitution would then mean that no person shall be deprived of his property or rights unless the legislator shall pass a law to take it away. And they said if the legislator could do that, that would throw their entire restraint away. So what restrains the government if the legislator could just write whatever he wanted? They do. They do it every day. They said the true interpretation of these constitutional phrases, law of the land, due process, is that where rights are acquired under the existing law, there is no power in any branch of government to take them away. They said this can't be done by an act of the legislator. They say again, the cause or occasion for depriving the citizen of his supposed rights must be found in the law. It cannot be created by a legislative act. Wisconsin, you'll never believe what they said. Due process of law does not mean the will of the legislator. That's what a statute means. The definition of the word statute means the will of the legislator. So the real meaning of a statute is it is the customs or bylaws of a corporation. That's what a real statute means. All right. And then you get to these law dictionaries where they done change the meaning. They say, okay, well, a statute is the will of a legislator. Okay, well, this thing called due process does not mean statutes. They said due process is the law here. They said the statutes is not the law. They said you can write whatever, you can't enforce whatever, not against the people you're supposed to be protecting. What is the purpose of the legislator? Thomas Jefferson says, okay, well, the purpose of the legislator is to secure rights. They said this thing called government is instituted among men. And this thing called government derives their just powers from the consent of the governed. Okay, well, what's the purpose of governments? To secure rights. So what's their job in writing legislative acts? They're supposed to be securing rights. But they write stuff to take them away now. They said, oh, somebody flip-flopped it. They said, we hold these truths to be self-evident. That we have unalienable rights, things you can't put a price on. They put a price on it every day. They say, you want your property back? Start making it rain, baby. We'll give it right back to you. They said to secure these rights. They said, what's the purpose of government? To secure rights. Okay, well, this thing called due process is then the law. The will of the legislator is not the law. The legislator can obey the law, right? They're bound by the law. Their job is to write things that will secure rights, not the rights of foreigners, the rights of the people who live on the land. Oh, that's another topic. That's another topic, right? Okay, well, they said this, Wisconsin said this thing called due process or the law of the land means the guarantees, and that if there are legislative enactments or rules duly made by its authority, they have to be consistent with constitutional limitations. See, this is what, I don't know if I'm allowed to say this, but this is what pisses me off, is because you go on YouTube, you go on the internet, you try to find law classes and not law classes, but law lectures that talk about, they don't talk about none of this, y'all. They're not being taught this in law school at all. They're not talking no due process. They said in a 3-year law course, a law program, they spend 1 month on this thing called the common law of England. 1 month. They say, yeah, they got this thing called the common law. Mm-hmm. Yeah, it's in the Constitution. Yeah, they got this thing called the common law. Yeah, due process, trial by jury. Yeah, they had this thing called a Magna Carta one time. They said they spent 1 month out of 3 years. Like they said, this is the law. They are not taught the law in law school. People tell me all the time, brother, I'm just going to go to law school. Why would you do that? Why would you waste 70 grand? I almost did it. I said, but I'm going to go there. I'm going to learn all of this. They're not teaching none of this stuff in law. They're not one law school is teaching this. Not one. I'd have wasted 70 grand for no reason, or 80, 100, however much law school costs now. You could spend 3 years, waste 100 grand, and never learn this stuff. He said, I'm going to go fight the child support industry. I'm going to go to law school. Yeah, they're not going to teach you how to win. They're going to teach you to obey the magistrate. That's what they're going to teach you. In 3 years, you're not going to learn nothing. They're going to teach you fake paperwork. They're going to teach you to obey what the judge say. Right? So that's not the law. And you won't find it. It's hard. People ask me all the time, well, who do I listen to? Who do I learn from? Good luck, bro. It's tough out here. Right? All right. Well, Wisconsin said, if you make legislative enactments and rules duly made by it has to be consistent with this thing called constitutional limitations. Wisconsin also said, okay, yeah, this thing called due process means that you cannot deprive someone of their life, liberty, or property. These things were prohibited by the Great Charter. What's the Great Charter? The Magna Carta. They said an arrest without a warrant has never been lawful in Wisconsin. They said an arrest without a warrant has never been lawful except in those cases where the public security requires it. They said an officer in Wisconsin is not permitted to arrest without a warrant for any misdemeanor. How many? Not any. Y'all get how crazy that sounds today? That sounds insane. Not for any misdemeanor. They said again, okay, this thing called an arrest cannot be made without a warrant unless, they said an arrest without a warrant has never been lawful except those cases where public security requires and has only been recognized in felony or breaches of the peace committed in the presence of the officer. Okay, they said if he didn't even see it, he can't do it. They said this thing called the Magna Carta, this book on constitutional law. Okay, they say you want to learn about constitutional law? They got this thing called the Magna Carta. They said it is clear that the common law is the foundation which that which is designated due process of law. When first adopted in Magna Carta, the phrases law of the land had reference to the common law and statute law then existing in England. And when embodied in constitutions in this country, it is referred to the same common law. It's the exact same one as what? The one in the Magna Carta. See, I didn't believe when I first started learning this stuff, I would hear people talk about the Magna Carta. I said, can't be. Can be. It's exactly what it is. The United States Supreme Court said at the point of a sword, the concession that neither lives nor their property should be disposed of except as provided by the law of the land. They meant law of the land as the ancient and customary laws of the English people. They said this thing called due process is secured so that the government is not subjecting the individual to the arbitrary exercise of powers of government unrestrained. What restraint? What is supposed to be restraining the government? Due process. They said this thing called the due process clause in the Constitution has its origin in the Magna Carta, that no free man shall be taken, imprisoned, or be disseized of his freehold or liberties or free customs, or be outlawed or exiled or in any way destroyed, nor will we pass upon him or condemn him, but by the lawful judgment of his peers. Who protects us from the unrestrained powers of government? The judgment of his peers, judgment of your peers. They said the court has recognized that this thing called the Fifth Amendment was understood to convey the same meaning as the words by law of the land in the Magna Carta. Let's see. Some stuff I can't read. Due process. Okay, they said this thing called due process convey the same meaning as the words law of the land in the Magna Carta. The constitutions which had been adopted by the several states before the formation of the federal, they said in constitutions which had been adopted by the several states before this thing called the federal constitution. They said we didn't get, remember we read it earlier, somebody, I think it was Illinois, they were citing Virginia. They said they said when we talk about the Eighth Amendment, we're not talking about the Eighth Amendment. We talking about when Virginia in 1776 had their own constitution. People said, these scammers on the internet say, well, really, there's two constitutions. Well, in 1776, there were 13. So what do you mean there's two constitutions? Right now, we technically have 51 constitutions. They said this thing called due process. Well, we don't look to the federal constitution to learn about due process. They said we got a due process. We got the same one. We didn't, that's for federal things. But when we're in Wisconsin, okay, well, we got due process. So they said constitutions which had been adopted by the several states before the formation of the federal constitution. Well, yeah, they said we already got this thing that says you can't deprive people of their life, liberty, or property, but by the judgment of his peers or the law of the land. They said even in the ordinance of the territory, the Northwest Territory Ordinance, they said, yep, they got the same words. Ask the congressman of the state for a copy of the state constitution. Technically, every state government has a physical copy of their state constitution on Amazon, but you could go to the Secretary of State, which I think that's who sets it up on Amazon, whoever works for the office of the Secretary of State. Florida says this. That's a good segue. There was somewhere else I was about to go. But Florida says, well, all the laws that are lawful will be held by the Secretary of the State. So if the Secretary of State didn't have a copy of it or didn't publish it or, recognize it, okay, well, then it wasn't. It wasn't. Let me see where I got it. I got it somewhere else. But if you want, you could literally go to Amazon, or if you don't do Amazon, then you will have to contact or find the Secretary of the State. So you don't have to go to the feds. A congressman is a fed. That's a whole topic by itself, but you don't go to the feds for state issues. You go to the state for state issues. So the Secretary of State would have a copy of your state constitution. And they also have it on their website. But if you want a physical book, Amazon will have it from your state government, or you'll go to the Secretary of State. Yep, Florida Supreme Court. I'm surprised. I need to put this on there. They said that the Florida Supreme Court said that we consider the Secretary of State has the indispensable legal duty to publish validly enacted laws. They said this is based on Article 4, Section 4B of the Florida Constitution. They said this is a duty imposed on him by Article 4, Section 4B of the Florida Constitution, requiring him to keep the records of the official acts of the legislative and executive department. So remember, I was saying earlier, okay, well, they'll just get on the news and say that they came out with a new law magically. And if you don't magically do these things, then you magically will be prescribed punishment before a trial happens. Okay, well, they said if it wasn't, well, they can't just do that. That first of all, when the news tells you something, that's not the government telling you something. That's why we're not supposed to watch the news, and we're not supposed to be believing attorneys. Right? So they said if it's a real law, then you would find it. They said the Secretary of the State has a indispensable legal duty to publish the validly enacted laws. I can't get that word out. But they said this is a duty imposed on him by the Florida Constitution, requiring him to keep the records of official acts, not just acts they put on the news, not just acts they put in the Florida Code. They said that's not the law. The Florida Code is not the law. Oh, that's where I was going. Does that make sense? Somebody say the Secretary of the State. And you can write them. You're supposed to be writing. If you really want to see if this law is valid, can you show me the official acts of the legislator publishing that, whatever? You have to write the office of the Secretary of State, but Georgia and Alabama. Georgia, Alabama, and Washington. Georgia, Alabama, Washington. Alabama. All right, so Georgia. So we're going to exit that one. Alabama. And then Washington State. Boom. Okay. So Washington says, well, the Fed said that if you want to find the official United States laws, if you want to find the official federal law, well, then that is the United States statutes at large. They said this thing called the code is only prima facie evidence of such laws. They said that's not where the law is. They said that's not the law. If you want to know what federal law is, you see all these scammers on the internet, all they show y'all is United States codes. They be on Cornell website. They be on, okay, well, the United States code said this, the United States code, and they call it law. That's not the law. It's never been the law. They said, if you want to find the official source of the United States laws, it's called the United States statutes at large. They said again, unless Congress puts a title of the United States Code into the law, they said it like it's two separate things. They said this thing called the United States Code does not prevail over the statutes at large. They said there's a hierarchy. They say that thing has to go from the United States Constitution to the United States statutes at large. You can't just start. That's what they do. They want us to believe that if it's in the United States Code, then it's magical law. No, sweetie. Another court, the Supreme Court, said this thing called the United States Code is immaterial. They said if your case makes it all the way up to the Supreme Court and you present us with the United States Code, we don't know nothing about no United States Code. We're here to deal with the law. They say, you want to talk about the law? Okay, well, you can't show us the United States Code and call it law. That's part of the problem too. I always get ahead of myself, but okay, well, they created all these fake inferior courts, and what they do is they essentially pack the courts. So for instance, New York State. Okay, well, New York State has a million type of courts, y'all. They got a criminal court, they got a civil court, they got a civil court, they got a civil court for this, they got a superior court for the civil courts, they got a superior court for that, and they got a mountain of fake courts so that you never make it up to the Supreme Court. People don't know this, but when you start appealing things up to the Supreme Court, it can take years. And then it may make it up to the Supreme Court and they say, yeah, we're not taking the case. Right? They say you can appeal for months and years and years and years. And it may make it to the Supreme Court and it may not make it to the Supreme Court. Like for New York, for example. Okay, well, they have so many state courts. They got so many types of state courts that you would have to make it all the way up to the New York Supreme Court. And if you didn't like that decision, then you would have to start the process of making it all the way up to the United States Supreme Court. There's 340 million Americans, y'all. Everything can't make it to the Supreme Court. It's not possible. And what's happening is this is where all the deception and confusion comes in. They're not wanting you to get things up to the Supreme Court, and then it may make it up to the Supreme Court, and they say, well, we're not going to answer it. They say we got more serious issues. All right, so the whole system now is, right? But they set up all these inferior courts to, especially in a place like New York, for example. Okay, well, you may never see the New York Supreme Court because there's so many fake cases being created, and then people say, well, this is unconstitutional, and they use this fake paperwork route to get everything up to the Supreme Court to answer a constitutional question. And then you may make it all the way up to the Supreme Court, and they say, well, why did you bring us the New York Code? or the or if you make it to the federal Supreme Court, why did you bring us the United States Code? They said, we're not here to talk about no United States. We can't talk about no United States Code. They say you're supposed to bring us a constitutional question. You're supposed to be talking about the law. We hear about the law. Well, they said this code thing was the law. Well, when you make it up here, we don't talk about codes. Codes are for inferior things. They say we answer a constitutional question based on a federal statute. Okay, well, the code is not. They said the code is immaterial. You can't admit that as evidence into federal court. Well, into the Supreme Court. They said again, this thing called the United States Code cannot prevail over this thing called the United States statutes at large, federally. In the states, the code is not the law at all. Okay, they got another case where they say, okay, well, this thing rests on the language that has been quoted from the United States Code. They said, where y'all getting this? They play so dumb in these cases. They said the United States, what's the United States Code? Ew, we never heard of that. Which is true. Their job, the purpose of a Supreme Court is to answer constitutional questions. You have to measure statutes, not codes, against the Constitution. That's the job of a Supreme Court. They say you bring up a statute against us, and then we'll measure and look at the statute compared to the action that happened and measure that against the Constitution. They said that's the job of the Supreme Court. So they said this dude keeps arguing language that has been quoted from the United States Code. They said, oh, no, yuck, yikes. They said this dude keeps quoting the United States Code rather than the law. The law? I thought the United States Code was the law. That's what they tell the police officer, ain't it? That's what they tell the federal agents. They say, yeah, that's the law. Good luck. And then you start measuring it against the statutes, right? What did Florida say? Well, they say, well, if it's valid, then it will be on the official acts of the legislator kept by the Secretary of State. Okay, well, I bet you $10. The Secretary of State don't have no United States Code in his office. That's not his job. He said the Secretary of State has an indisputable legal duty to publish validly enacted laws. This duty is imposed on him by the Florida Constitution, requiring him to keep records of the official acts, not the code. They say he don't keep the code. He ain't got no code in his office. They say he has to keep the records of the official acts of the legislature and executive departments. All right, so they said Washington State, and Washington State says, okay, yeah, this thing called the Code of Washington is not the law. They say it twice. I got two cases. They said this thing called the Revised Code of Washington, the RCW, is not the law. Okay, well, if the Supreme Court said it ain't law, it can't be law. What's the law of Washington? The Supreme Court of Alabama said, yeah, this thing called the code is not within the letter or spirit of mandate of the Constitution. They're talking about the criminal code in Alabama. They said in Alabama, the Supreme Court of Alabama don't know no such thing as a criminal code. They said this thing called the code is not within the letter or spirit of the mandate of the Alabama Constitution, nor can it be supposed that it was within the contemplation of the framers of the Constitution of Alabama. Uh-oh. It's people sitting in Alabama jails and Alabama well, technically they're not Alabama jails and Alabama prisons. Technically, there's no such thing as a state jail or a state prison. They're all foreign, but that's another topic. They said this thing called the Code of Alabama, they made it for convenience. They didn't make it as the law. They said we can't call it criminal legislation. That's crazy. I forgot about that. All right, then you get to this place called Georgia, and Georgia says, yeah, a code in Georgia is not within the letter or spirit of the mandate of the Georgia Constitution. They said this thing called the Georgia Code Annotated is not the law. This is the Supreme Court of Georgia. They said this court, what court? The Supreme Court of Georgia. Just like you remember the United States Supreme Court said, oh, we don't know this thing called the United States Code. Okay, well, when you get to the Georgia Supreme Court, they said, what they say when they crucified Jesus? Oh, I wash my hands of this. I ain't find them guilty of nothing. You get to the Supreme Court of Georgia, they said, we don't know nothing about no Georgia code. Who did that? They said that's not the law. They said this thing called the Georgia Code Annotated is not the law. They said the legislator did not expressly adopt it. What they say about Florida? They said if the Secretary of State don't have the official records of the act of the legislator, it's not. This is all due process, baby. This is all due process. They said, this is the Supreme Court of Georgia. They said there's been no legislative enactment adopting the code as the law. That's all they give out is the United States codes on a citation, y'all. You ever got a ticket in Georgia? Don't do it. What they call, I forgot what they call. They got green. They got the ugliest state trooper cars. They got green and orange state trooper cars. Not green and orange, blue and orange state trooper cars. Yeah, and you get a citation from them, and it's going to be a code on there. It's going to be the Georgia Code Annotated on there, saying you were speeding or you ran a red light or you, no inter-party, no law. They said, oh yeah, the Georgia legislature never adopted this thing called the code. This stuff is crazy, y'all. They just disobey the law every day. And want you to believe it's the law. Want us to believe it's law, though. They came out with a new law yesterday. No, they didn't. They never adopted it as law. They said there has been no legislative enactment officially adopting the code as law. They write fake laws. What they say? Pretended legislation, a pretended act of parliament. Go to the Declaration of Independence. Search the word pretend. Pretend. No, they saying more than that. They said he is combined with others and has given his assent to their acts of pretended legislation. He has transported us beyond seas to be tried for pretended offenses. They say it another time. I thought they said it 4 times. Guess not. Let me see. Oh, offenses. Let me see. Offenses. Legislation. We have warned them from time to time of attempts by their legislator to extend an unwarrantable jurisdiction over us. Pretended legislation. Fake laws, baby. They said they never really did it, but they enforce it like they really do it, don't they? They said this thing called the Georgia Supreme Court cannot take, they said this thing called the Georgia Code annotated does not constitute a legal citation. We cannot take judicial notice of it. They said again, when this thing called the code makes it up to the Supreme Court, they said, what's a Georgia code? We never heard of a Georgia code. They never enacted that. They said we can't find that in the law. We can't make it, does not constitute a legal citation. That's all them attorneys argue is the code. They don't argue no common law. They don't even argue the Constitution. They said, where y'all get this code from? They said they trained the Georgia State Troopers on the code. You go, you get pulled over. He gonna have the big book of the code in his car. And the Georgia Supreme Court said that's not the law. They say it again. The code, this is a third case. They say, yeah, this thing called the codification was not the law. They said to codify something was not to codify the law, was not to make law. They said by codification was not making the law. You see how crazy that is, y'all? All right. I think that's it. I think I'm gonna get on up off of here. Due process, due process, due process. There was something else I was gonna read, but I forgot it. But yep, I'm gonna get up off of here. Yep. All right, we will try it again tomorrow, maybe. So how is it enforced? Good question. It is enforced because we went to this place called the DMV and got a state ID. It is enforced because we went to this thing called a car dealership and allowed them to give that car's information over to the DMV. So if you want to stop being enforced against by statutes, you have to rearrange your life. Stop driving cars, return the state ID. Stop driving cars. Now, you can't do that overnight. Most people are not prepared to do that. So just because I say it easily don't mean you can do it easily. You're going to have to figure out how to get from point A to point B. You're going to have to rearrange your life. That's easier said than done for a lot of people. But you get rid of them two things and work on getting out of the system, you'll have a good fight. Start learning the law because the code is not the law. All right, I'm out.